Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Rausen Pereira. The government introduced the Insolvency and Bankruptcy Code Amendment Bill 2019 in the Rajya Sabha on Wednesday, seeking to restrict the duration of the resolution process and ensure the primacy of financial creditors in case of recoveries. The resolution process is proposed to be limited to 330 days, including time for litigation. The bill seeks to remove ambiguities that had arisen due to the order by the National Company Law Appellate Tribunal on Essar Steel's insolvency resolution. It is set to help classes of creditors such as homebuyers who are represented on committees of creditors by a single authorised representative. Key clarifications in the bill will put the Committee of Creditors in control of the distribution of proceeds from a successful resolution plan under the IBC. The amendments clarify that the unsecured financial creditors and operational creditors need not be treated on par with secured financial creditors for a resolution to be considered fair and equitable. On this edition of The Big Picture, we will analyze the Insolvency and Bankruptcy Code Amendment Bill of 2019. Joining me on the program today are Shubhamoy Bhattacharjee, Consulting Editor of the Business Standard, Aman Agarwal, Director, Indian Institute of Finance, and Ashok Kumar Jha, former Finance Secretary, Government of India. Thank you to all my guests for joining me on this edition of The Big Picture. Ashok Jha, I'd like to begin the program with you. As far as the IBC is concerned, let's first try and understand, ever since its inception, how has it helped the NPA problem issue?
Well, I think it's been one of the best reform measures that the government took in order to make sure that creditors and debtors, the relationship is put on an even keel. Before this, basically the creditors were running after their debtors. Now, after this came into force in 2016, there is a certain amount of responsibility, certain amount of accountability that has been thrust upon the borrowers, and they are a little more careful in dealing with the with their creditors. See, earlier we had, before the IBC came into force, you had various measures. You had the SICA, then you had the SARFAESI, and subsequently you had various measures like your 25 by 25 scheme and various other schemes. Basically, these were, I would say, by and large, they were persuasive in nature. Barring SARFAESI, which was confiscatory, rest of them were persuasive. You are basically trying to convince the borrowers that it's a good practice to pay back the money they have borrowed. Now, this IBC now, this is something which if people adhere to the timelines, it is something which has already made a great impact. And I think after the amendment, if it goes through and when it goes through, the impact will be far, far greater.
Right. Shubhamoy, let me bring you to the picture now. So, what are the main changes really in the amendment that the government would like to bring about?
Well, one of the first things is, as you said, that it basically limiting the all the issues concerning litigation to a 330-day window. The other thing, and that is the biggest thing, is that essentially the financial creditors get supremacy over the operational creditors. Now, why is that important? It is important because, after all, a bankruptcy process, there is a standard waterfall, and in that the financial creditors always get, as in the normal course, first priority. It is how businesses also are made, to wind up globally. And there's a reason for that, is that if you do not do that, then why do financial creditors give loan to a company? They give their loan at a particular interest rate because that interest rate factors in that in the period of, if there is a resolution, then that resolution they will get the primacy. If this law, which suddenly the NCLAT, as you pointed out, overturned, then the problem comes along, then the entire business basis on which the banks have given the loan to those companies comes asunder. There's no basis for it. They've been seen as taking risk far more than they should have. So obviously it was something that would have thrown our entire financial sector into a turmoil, because at one stroke, if this, for instance, let's take the counterfactual, if this had stayed on, interest rates would have jumped for any credit, because creditors would have said that I have to take care of the fact that if there's a resolution, if there's a bankruptcy case, I'll not get any primacy, I'll not get any priority. So that was the reason why the government, and it's to be given credit to the government, that it swiftly moved in, and it's one of the fastest ever response by the government to such a judgment, and it was very necessary, very timely. Everybody across, I mean, the entire financial sector has welcomed it, that this was extremely necessary.
You know, in the Supreme Court took cognizance of the matter.
Absolutely.
It's not just the government.
Yeah, because the case was coming up in Supreme Court, the Essar case, which actually led to this entire thing. And if this law had not come through, if the cabinet had not approved it, and yesterday the finance minister piloted the bill, then Supreme Court would have said, well, the decision is out, I mean, not yet cleared, we need to think about it. It would have gone back to its case laws to think about, and overall we would have had a very, very difficult financial environment, which would have, as Mr. Jha is pointing out, I mean, all the benefits that we had secured would have been overturned.
Right. So let's look at it from the other perspective as well. As you know, Aman Agarwal, the unsecured creditors now, shouldn't they also be given a level playing field?
No, I think the bill as well as the amendment has provided for that through the voting framework, and that's given all communities an equal component. And the fact that even those voters who vote against the decision being taken, they would also get the pie in the equal format as they're supposed to get, and in case the amount comes more, they will get it bigger. Whichever is higher is going to be given to them. You know, it's interesting to note that when the whole journey of the IBC started, and today when we look at the perspective, at that time we were having an NPA level of about 7.4 lakh crore was the level of NPAs we were having, NPAs we were having. Today, after 2 years, about 5.24 lakh crore NPAs have been resolved through the IBC. So a large chunk of it has got resolved, and I'm told roughly about 21 companies, a huge chunk of about 4 point some lakh crore was actually collected from those 21 companies. There are about 1300 cases still pending. But please understand that before this came in, till 2015, for almost about 20 years, about 16 lakh crores was being waived off, almost about a lakh of crores was waived off by the banks every year. The government was waiving it off. That means that was a cost to the people of this country, because ultimately it was the taxpayers' money which was being used to waive off these loans. Now that system has completely been abolished, and this new framework which has come into place is bringing in the money back into the system, which could be used for growth and development. Now these are two major chunks. One is that we stop that pratha or that kind of custom wherein the government year after year will actually waive off the NPAs from the banks and financial institutions, tuning to about 1 lakh crore every year. And then the second is the money which was in the market but could not be brought back to banks and financial institutions will come in, and the other sects or acts of the law which were giving certain preferential treatment to certain segments of the people in the company for their resolution or getting the money out, what has been set aside, giving the financial and banks given the preference to them, as they are also the largest vote shareholder because they give the largest chunk of money. So there I feel it's bringing out equity, it is giving justice, and what we have seen happening in last 2 years, we may see another 6 months of time after this act, this amendment taking place, we will see that kind of recovery happening even faster now. Certainly there have been some new builds up also which have not been accounted for, but I think things will resolve off the way the ministry and the government is taking this, trying to bring people's money back to the system, because ultimately bank or any financial institution is a custodian of large number of investors and individuals of this country, and ultimately the government as well. So it's important that this money comes back into the system, and which can be then used for growth and development, whether it is MSME or through Mudra or through other components which the government wants to bring in terms of growth and development for this country.
Right. So Ashok Jha, correct me if I'm wrong, but I think there are a couple of amendments already to the IBC we've seen over the last couple of years. So why is there a need for this amendment as well? What does it bring about?
See, actually, I think there are two major issues that this amendment is supposed to handle. The first major issue was about operational creditors and financial creditors. Because of this Essar case, there was a judgment given by the NCLT that both were to be treated on par. Now, that obviously is not a very sound conclusion, because there is much more risk that the financial creditors take. And as Mr. Chakravarti also mentioned, there is, I mean, if you do not give due primacy to the financial creditors, then the cost of credit will go up. So there is no doubt that had to be done. The second point here is in terms of the timelines. See, the timelines, although in the original act you had 14 days for the matter to be decided as to whether it deserved to be treated as default or not. And then after 14 days, they were given 180 days in which to come up with a plan. And that 180 days could be extended by another 90 days up to 270 days. Now, as we all know, many cases have gone way beyond 270 days. The Essar case, of course, has been more than 500 days or so. So you needed to put in timelines. So now what this amendment is proposing to do is that it is fixing a timeline of 330 days. And the amendment says that if it is not decided by, and that 330 days includes the timeline as far as the legal process is concerned. And if it is not decided finally in 330 days, then it will go in for liquidation. Now that is a big threat hanging over all the borrowers, because the liquidation amount, if the company goes into liquidation, will be a small fraction of the amount that they would otherwise be able to get. So I think that is the most important thing, that the timeline is sought to be restored, although I am not very sure right now as to how they are going to implement this timeline. Because if again people avail of the due legal process, it can get again elongated. So it's going to be very interesting to see how this particular provision is going to be implemented.
That was going to be my next question, Shubhamoy. So how is this really going to be implemented? How will the bill ensure expedition of insolvency cases?
Well, if you look at the statistics, most cases have stuck to that 270 thing. It's only the marquee cases which where the numbers have gone, dates have extended, and they are the ones which naturally we all talk about, discuss. So that seems to be the case. So that isn't in fact, one of the advantage of the IBC has been that there's a provision under IBC which says that if a company comes under IBC and if the creditors and the company both want, they can take it out of the IBC and resolve it sort of an out of court settlement. And there are lots of companies, about 66 of the last, if I remember, last quarterly figures that it had come out, had taken that advantage. So, IBC works at several levels. It's not just that it'll be companies, will keep on stretching it out. What it also does is, there are not too many laws in India where there's a date or timeline fixed for settling disputes. We have had, I mean, that's one of the most interesting things about Indian judiciary's cases, that cases go on for years. Civil cases, environment cases, labor cases. As a result, what happens is crucial factors of production get stuck. So whether it's land, whether it's labor, whether it's capital, that gets stuck. If this one more or less is agreed that this is a template, then I see hope that in other cases relating to land and labor, where dates have, years have stretched out, could also be brought under similar disciplining mechanism. They haven't been thought about as yet, but there's a discussion on that should be there. And it's very necessary, because only then, when we say that this is going to finish, can companies, can investors say that, I have a chance to bring in capital, I have a chance to set up a unit, and if the unit doesn't work, then I can also phase it out within a more or less agreed time. And that's very important. I mean, we are talking about the ease of doing business. In the ease of doing business, what is the main thing? That, there should be that not only opening up, but there should also be a time limit for closing down a business. And that both parts of it work only when the economy progresses.
Sure. And since we're talking about the judiciary and everything that's associated, all the issues that are associated with the judiciary, the bill also talks about extensive litigation. Now, that has to be addressed on, on a fast track basis as well. Aman Agarwal, if going forward, if we have to ensure that these timelines and everything that's mentioned in the bill are met.
No, I think the government has clearly showed its intention, its structure, that it means business, and it would like to end it up in business, not to take into account the fact that the kind of laxities which happened in the judiciary, and that has to be curtailed to that period. And they have said, if it does not happen, we will proceed with the order. So they very clearly made it that whether it should be resolved in those 330 days or we will issue the order. Two interesting other parts which have come out actually in this amendment is that in the 14-day period when they are supposed to take, the IBC is supposed to take a decision of whether taking in or not taking in that case, also it has to give a logical reason as to why is it not taking in and why is it taken in case they surpass that 14 days for taking in, and in case they do it within that. Second thing which they have done is they have allowed the issue of mergers, acquisitions and amalgamations or corporate restructuring to be allowed as one of the sets within the framework which was there. So it was a confusion whether it should be allowed or not, and even that, for that purpose, each time they will go back to the judiciary. This time now you don't need to go back, because within the framework it has been set in that if you want to go in for that particular framework where you want to do a merger, acquisition or you want to get corporate restructuring done, you are welcome to do that, whether it is going off the case or within the case framework. But what needs to be done is the 330-day time limit needs to be maintained, and I am happy that this has come forth after a long time. I hope with other things also we will have these time limits. I remember in the US, for any case registered, they have a 2-month time limit in which a case has to be resolved on one side, so that there is justice accorded to the person who is being subjected to it. Whether he goes to the next level, he has the right to go to the next level and third level and the fourth level, but at least he must have a time frame that my decision is taken for or against. And I think this is something which has been set as an order here, and we will see this being replicated to other regulatory frameworks in due course, so that accord could be justice, people could get justice, and ultimately people could get the right kind of relief, especially the masses whose money gets stuck up in most of such cases.
Absolutely. So are there any sections that will benefit once this bill is passed, Ashok Cha?
I think well, firstly, all the creditors will benefit. Then even the home buyers, this amendment is also taking care of the interests of the home buyers. So even they will benefit. And if the creditors benefit, which includes the home buyers, the entire economy benefits, because the money which is today just locked up without producing anything, that money will be recycled in the economy. You will have fresh investment coming in. And most importantly, I think the credit culture, which over the years had got totally knocked off its normal standing, that credit culture will come back. People will borrow money with a sense of responsibility, knowing that they have to pay it back. If they don't pay it back, they may even lose their companies. So I think that's the most important takeaway from this.
Talking about home buyers, Shubhamoy, this bill, along with what happened in the Supreme Court as far as the Amrapali projects are concerned, does that give a ray of hope to other home buyers as well, who have been stuck in this cycle, really, who have invested in projects that are now bankrupt? JP comes to mind immediately. Is all of this going to ensure that the consumer or the end user, eventually their lives are going to get better?
Well, there's a bit of a iffy thing there, because if the financial creditors get first choice, then obviously they take away the lion's share. So it doesn't necessarily help the home buyer. Though of course home buyers have been brought in as at par, but then that itself could be questioned very soon, that do they have the right. So I don't think this code is essentially a substitute for RERA, which is the regulatory authority for the real estate, and that is where the issue stands. But to the extent that any resolution is happening in any sector, it automatically has a good spin-off effect. It does directly or indirectly also help. Home buyers case, in the JP case, for instance, Supreme Court has actually carved out a very interesting solution. It has actually asked NBCC to get into it and start working on the projects. Not that every other projects can be looked at through the NBCC, and the government cannot stand as the provider of houses for all and sundry. But the point is true that this is also a sector where there's a lot of money is stuck. And if people don't find themselves being comfortable, then yes, we are talking almost regularly every second program about consumption returning to the market, demand revival. Well, those things won't happen unless these things happen. So these actually have a very strong positive spin-off on those sort of things, because if people get back the money, then they can feel confident that to take up some other investments. and very true. Again, the role of judiciary. You know, recently the judiciary has hired, I mean, I found it a peculiar idea. They have taken up a huge building on in front of Apughar, where Apughar used to be there, and that building is to store the records of the judiciary. Now, in these days, who records those paper documents? It's sure enough that those documents will never be able to come out of their places where they've been stored. Instead, if the judiciary had been smart enough, they should have gone in for massive level of digitization and ensured that just a single computer server maintains those documents. I mean, just a building of documents. I mean, how more archaic can it get? But that's what has happened. So I think there's some serious reform issue that's coming up there.
Sure. So let's broaden the scope of the discussion a little more, Aman Agarwal. So as far as NPAs are concerned, what more needs to be done to deal with the problem, do you think?
No, I think when it comes to NPAs, it is not, it's become a customary problem because, and it became systemic in nature because of the fact the way loans were being given out and the NPAs were being waived off by governments one after the other. Even this government in the previous term, way back in 2003, 2004, had waived off, as I said, about 16 lakh crores were waived off in the last 18-20 years. Now, so there have been governments after governments which have been waiving off NPAs. So it had become a culture. So it had become a cultural frame. But the recent steps taken by this government in this previous term between 2015 till now, and now recently the amendment which is being taken place, clearly is giving a message to the borrowers that the money is not for free. You have a liability, you have a responsibility, and you owe that responsibility to pay back this money. You have only taken this money for usage and not for the purpose of as a free cash flow for your own self. And I think that is very clear. Fortunately, you know, this framework of even small home buyers or small creditors has been taken care of, because you see, many times they do not have a voice. So what has been given in this framework is, when it is creditors, certainly a large chunk, 50% and above, are the ones who have a voting voice, but those are mostly the banks. But whatever decision is taken is equitably divided amongst all creditors. So no longer are even small creditors left out from the framework. Certainly, even if they say no, it has been clearly given that it will be there. So in my opinion, what needs to be done more is for regulators to see and talk to the framework which is actually giving out loans, to see that these people who are supposed to be custodians of actually getting that money back are put in order as well. Break away from the kind of customary systems which have been created, make them accountable. You see, we have recently, only last 2 years, 3 years, this government had started questioning chairmen of banks or boards of banks. Now that could have been done before, because crores of rupees worth of projects cannot be approved except it is brought to the board. So naturally the board knows about these projects, but unless both government officers as well as people sitting on these boards and the senior officers of banks and financial institutions, unless they are made accountable, unless they are at least asked what is happening, what is not happening, we will not see this matter getting resolved even faster. What needs to be done, we need to streamline the system by making accountability, and I hope this government, given the tune which has shown, it is not only penalizing people. You see, as someone who has got used to a framework, he is naturally bound to do the error again and again. If he has become a thief, he is happy being a thief, why not live a life of a thief? So by just naming them as willful defaulters will not help. It is correcting the system. Who is creating those willful defaulters? Who is enabling creation of those NPAs? If you give rewards to some of these people who are holding senior positions one after the other and not bring them to check, which has happened. We saw in the last 2 years, some of these senior officials have been brought to check. Right. And that is where there is a fear psychosis in that group as well, that if I do something wrong, I can be also booked to check. Now that is something which is very critical, not only in India only, but even worldwide. We saw that bankers have been actually brought to the books by the parliaments in their respective countries. Now this is something which has been a recent move after almost half a century of defaults after defaults, or NPAs after NPAs being created by banks and being waived off by governments. So I think the government is on the right path. It's only a question of bringing accountability to the system, and I think if we are able to do that, people at the end of the day, the people on the ground level whose money gets stuck up, would be the ones who will be the most happy and the most rewarding for them.
Absolutely. All right. Closing comments from all my guests with the best way forward, starting first with you, Ashok Jha.
See, firstly, of course, I would like to make it very clear that all the NPAs are not as a result of some crookery by the borrowers. Okay, that the fact of the matter is that when the economy was growing very rapidly between the years 2003 to 2008, everybody thought that demand would continue to increase. So people who are in the steel industry, cement industry, all the other industries, they took the fact into account that the economy is going to be growing at 8%, maybe even 10%, and therefore they went in for heavy investment. And then the entire thing collapsed globally. There was a collapse in the global markets. So all the NPAs are not as a result of, I would say, crookery by people, but it was, you can say it's a business failure. Some of it may have been because of crookery, but a lot of it was business failure. So I think that is one point that we need to distinguish between the two. But having said that, the IBC is definitely going to improve matters, because it is those who were inclined earlier to treat bank loans as their own personal property to be returned or not to be returned depending on their whims. I think that will get corrected.
Sure. Shubhamay?
Well, the interesting thing from here is the way the government responded very quickly. And I think that is what should be an interesting thing. The government should be able to show that whenever somebody is trying to game the system, it will not stand for it. If that is shown in other cases also, I think we are in for an interesting time.
All right. And Aman Agarwal, close the show for us with the concluding
Yeah, I
remarks.
think in addition to what has already been done by the government in the way they are moving forward, I think they need to bring a check on the way regulators are actually introducing certain new norms which are actually killing large part of the industry and segments from growth. And instead of making ease of doing business, it's actually being detrimental in some of the regulators which are doing in different industries in the country. Now that's where they need to bring a check. It is easy to punish, but it's a difficult thing to give a supporting hand to bring them up. What the government has been focusing in the last 5-6 years is to give that supporting hand to almost all segments of societies. I think different components the regulators also need to focus on and become enablers than just being regulators.
All right. On that note, then we'll call it a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. That's it from me. See you again next time.